Two parents say they thought they were doing what was best for their children by feeding them a vegan diet consisting of only raw foods. But it didn't seem to make for a healthy lifestyle because an autopsy of the Andreessen's youngest child showed she died of malnutrition. Good afternoon and welcome to Both Sides. I'm Kimberly Guilfoyle Newsome. Vinnie Politan has the day off. And today on Both Sides, we'll be showing you some important testimony from the state's rebuttal case, and we'll be discussing the ultimate question before the jury. Are the defendants guilty of the top charge against them? And of course, we want you to get involved in our discussion, and you can do that by answering our email question of the day in just a moment. And today, we are joined by a very special guest who I'll reveal to you shortly. But before we get to all of that, for more on the case, here's Court TV's Jean Casares.
Every parent wants their children to eat right, but can a healthy diet be deadly? Joseph and Lemoy Andreessen stand accused of starving their baby by feeding her nothing but organic vegetarian foods. The parents dispute the claim.
Anyone who has parents should sit back and just imagine first being charged with something that's just out of the ordinary, and then secondly, having your children taken away.
The Andreessens follow a strict diet of organic, uncooked foods. When 6-month-old Woya Andreessen died, she weighed just 7 pounds. Doctors found nothing but wheatgrass in her stomach.
Baby Woya wasn't old enough to talk. Baby Woya could not say, the evidence will show, "I'm hungry. Give me some more to eat. This wheatgrass isn't enough. I need more."
Authorities took the family's 4 living children out of the home and charged the parents with manslaughter for Woya's death and child abuse for 4 other Andreessen children.
The kids were already traumatized when they were taken out of the family's home, initially because the 6-month-old sister of theirs died. Now, after 2 years, it may well be, if the parents are not successful at trial, that they will not be able to be reunited with the children because the parents very well may go to prison.
The defense maintains that Woya was born with congenital defects that led to her death.
You can see particles of what she ingested in the lungs where it shouldn't be, and that caused the child to develop the beginning stages of pneumonia, and the baby was not able to fight it off, and the baby died because of those reasons. It didn't matter what the diet was.
The jury will also hear emotional accounts of the Andreessen home from the surviving children.
Mom and Dad tried to let Woya let Woya eyes together, but nothing worked. So she did it. She didn't make it.
She didn't wake up in the middle of the night?
So she didn't make it in the middle of the night.
Oh, she didn't make it in the middle of the night. But what did she die from?
I got probably from the sides. The doctors don't know how she died.
The Andreessens face 50 years in prison if they are found criminally responsible for a natural diet that endangered the children and ultimately killed their daughter.
And joining us now to help analyze this case is a great panel of guests. First up is Jennifer Rosado. Jennifer is both a professor of law as well as the Associate Dean for Student Affairs at Brooklyn Law School. And Dean Rosado's area of interest focuses on family law with a special emphasis on ethical and legal issues related to healthcare decisions made on behalf of children. Sounds like a perfect guest, right? Can it even get any better? Yes, all right. Also joining me on set while Vinny takes some time off is a very special guest. You can see him, right? Florida Assistant State Attorney Herb Walker, who prosecuted the Andreessens and has come all the way from Florida to help us understand this case better. So great guest today. Pleasure to have you with us, Jennifer and Herb. What a pleasure and honor. As a former prosecutor and as Jack Ford came in, you met him during the break here. It's such an honor to meet you. You did such an outstanding job in the courtroom. We've enjoyed your work and your ethics, the way you've handled it all. So let's start with Jennifer first. Jennifer, you have a particular expertise in handling these kinds of cases and issues. What were your initial thoughts when you reviewed this case?
Well, my initial thoughts were of other cases that had come up, some in the late 80s and some more recently, about parents who had a particular lifestyle that ended up in the death of the child, and how to handle that, and saying, first of all, what a very sad situation, and secondly, how are we going to deal with this from the criminal and from the family court family court perspective. Very difficult.
And they're two separate entities, because a lot of our viewers have emailed in wanting to know, who's in charge of what aspect of it. The prosecutor's office brings the criminal charges, but there's a whole separate division that deals with the welfare of the children. Explain that.
That's exactly right, and it's very important in this case. The prosecutor here has to make the decision about whether there's enough to charge criminally, both for the manslaughter as well as the child neglect. But those standards are criminal standards, and usually higher than those that are in family court. And the criminal aspect is really to see, do you need to try this case to deter other parents from engaging in this behavior and to punish these parents for what they've done? The family court is more, how do we keep children safe? So really the mindset of the parent isn't so important. It's what we need to do to try to preserve the parental rights if we can, but also help the children if we need to.
All right, let's talk to Herb about that. I mean, because a lot of people, there's some confusion and some comments that the defense attorney has made suggesting that, the prosecutor's office, led by you in conjunction with law enforcement, et cetera, is out in kind of this conspiracy to tear this family apart. How do you respond to that?
Well, in a word, I would say that's nonsense. The reality is a baby died here. You have to look at the circumstances under which the baby died to make a determination as to whether it would be appropriate to file a case. In this case, Dr. Mote and the other individuals at the Miami-Dade Medical Examiner's Office did take a month to investigate this death. They didn't rush to judgment, even though Dr. Mote said he was 99% certain that the cause of death was severe malnutrition. At the time he did the autopsy, he wanted to take more time to make the right decision. Based upon his determination, we then made a determination that as a matter of law, this rose to a level of recklessness that is criminalized. We never suggested that the parents intentionally killed their child. Had that been the case, we would have filed a charge of murder. In this case, we've suggested that because of their gross and wanton recklessness, they provided no medical attention for the child and no nutrition, and the child died. As a result, you have an aggravated manslaughter, and as prosecutors, we have an obligation to protect the public, the people of the state of Florida, and that's what we did in this case, and that's our obligation, that's part of our oath.
All right, well then, there you go, and that's exactly how it should be done. And now in terms of the children and their welfare, you weren't the one that decided to say, oh, we're not going to allow the children to see their parents or anything like that.
No, what actually happened was the parents initially were placed in jail, they bonded out and were placed on house arrest. They were allowed visitation rights with the children, and we heard Aunt Mary talk about that. In fact, it was at the visitation that the defendants actually told the kids that baby Woya had died because they fed her too many vegetables, but that it was an accident. However, sometime after that, one of the parents' friends, an individual who was involved in earlier defense team, did a videotape recording of the children. In essence, they staged a party, if you will, with fruits and vegetables and asked them questions about the fruits and vegetables. Based upon that and other conduct, a criminal court judge found that that was in violation of the conditions of the parents' release, and a criminal court judge decided, not at the behest of the state attorney's office or Aunt Mary or the medical examiner's office, but the court decided that he was going to invoke a stay-away order that precluded the parents from having any contact with the children until the trial, because of a very real fear that the parents may be in fact attempting to influence the children's testimony at trial, and maybe in fact emotionally harming the children by continuing to bring up the issue of vegetarianism. So that had nothing to do with the state attorney.
That's fascinating, because I don't think even our viewers didn't know that. You're getting firsthand information here. It's fantastic to hear that and learn the aspects of it. All right, well, we're going to be talking with our panel of guests throughout the show, but for now, I want to take you back into the courtroom where we are in the state's rebuttal case, and on the stand is Dr. Maria Rodriguez, a director of pediatric pathology. She is being cross-examined by defense attorney Ellis Rubin about DeGeorge syndrome, a condition the defense has suggested actually caused the death of Woya Andreessen.
Doctor, am I correct that according to positive pathology, one of the characteristics of DeGeorge, or partial DeGeorge for that matter, is deficiency of T-cell development?
That is correct.
And another recognized symptom of DeGeorge, according to Potter's pathology, is a partial or total decrease of thymus and T lymphocytes, right?
That is correct.
And so according to Potter's pathology, which you recognize as an authority.
Objection to that, Judge. Just the question needs to be posed.
No, I think this is the first part of the question. As part of pathology, that you recognize an authority, comma. Now the rest of the question is going to go, because she's already said that she recognizes that as an authority. So I think it's just leading up to the question. Go ahead.
Thanks,
If that was a statement, I would agree that we needed the statement. Go ahead.
All right, well now I got to start over.
Okay, as a Potter's pathology, that you recognize an authority, comma.
Based on Potter's pathology, which you recognize as authority, you would agree then that a partial decrease of the thymus is consistent and recognizable as a symptom of DeGeorge.
But it's not only DeGeorge. That is my problem. You're making this as the only disease in the world that has a small thymus is DeGeorge, and that is not true. That is the main problem I am having. The other problem I am having, you mentioned before that the parathyroids, if the parathyroids cannot be found, very seldomly do I find the parathyroids when doing an autopsy because they are tiny. So you will have to completely section the entire upper airway to be sure that they are not there. So you cannot assume this baby did not have, because of one section, if any was taken. That is a problem. Okay?
Now, here on both sides, we love to hear from our viewers about the trials that we are covering. And today, we want to talk about the possible verdict in this case. The Andreessens have been accused of starving their children with a raw food diet. Prosecutors say the couple caused the death of their youngest daughter.
Well, the important thing is that the parents violated their sacred oath to their children to raise them in a safe and secure environment. As a result of that violation, the youngest of the children died a slow and painful death by way of malnutrition.
Welcome back to Both Sides. I'm Kimberly Guilfoyle Newsom, and today we have a very special guest sitting in Vinny's chair. I'm really excited. It's like Christmas for me to have such a great prosecutor next to me here. And a sharp dresser, man. Look at him. All right, Prosecutor Herb Walker, and I'm going to take this unique opportunity to put our guest on the hot seat. No, not as bad as I did with Ellis Rubin. But the state has said that the Andreessens' raw food diet led to the death of their 6-month-old daughter. But they had 4 other children at the time who are still alive. And the defense says there's a reason for that.
This couple had 4 other children before the child who died. They lived on the same diet and the same progress that the little girl who died, who never had a chance. It didn't make any difference what the diet was for the child who died, because she was doomed because of these congenital defects.
So, Herb, now is there any meat to the claim that the raw foods are not to blame for baby Boya's death? And did the state investigate the possibility of the birth defect, the DeGeorge syndrome?
Well, to answer your question, no, there's no meat to that claim. Clearly, Dr. Mote pointed out during his testimony that when he found that the thymus had involuted, meaning that it wasn't visible to the naked eye, the first thing he considered was DeGeorge syndrome. He said it's really, really rare, and that he had actually done an autopsy on a DeGeorge patient some time earlier, but that it's very rare. So what he had done was a CD3 test. That's a fancy name for a type of test that tests for T cells. T cells come from the thymus. That's why they're called T cells. If you don't have a thymus at the time of birth, you can't possibly have T cells. If you do have T cells, then you must have had a thymus at some point. Just like you can't have a child without having a mother, you can't have a T cell without having a thymus.
Got it.
In addition to that, he did an investigation of the body. He said, and his testimony was that there should be some type of macular dysmorphia, which means that your face looks really funny.
Right.
We didn't find that. He said he tested the inside of the body. There should have been defects to the heart. aortic arch of the heart should have been deformed in some way. We didn't find that. The other internal organs should have been affected if there had been DeGeorge disease. We didn't find that. We ultimately got the CD3 test back, and that just confirmed with what Dr. Mote had determined at the autopsy. In fact, we introduced during the trial, and we're going through that now, the CD3 results, the photographs of the T cells of baby Woya as matched against a normal child.
Right.
And we saw that baby Woya has just as many T cells as a normal, healthy child. That completely rules out DeGeorge.
Yeah, so there's no other factors or indicators to support or substantiate a diagnosis that she has DeGeorge syndrome.
Absolutely none.
Well, there you go. Well, we know that Woya's autopsy revealed only 8 ounces of a grassy-smelling fluid in her stomach, but Lamoy Andreessen claims she also fed her daughter her own baby formula concoction.
We're asked to submit a sample of the diet for the children and the baby formula, and she did. And the medical examiner received it, but he never ordered it to be tested for its nutritional value, which if they had done that, and it turns out that it wasn't what the mother says, then she's a liar and they have a case. But they didn't do it.
Okay, so Herb, now why didn't the state have the formula tested for its nutritional value, and do you think that that had any impact on your case?
No, we believe it had no impact, and the reason why it wasn't necessary to test it is because it was never an issue as to what it was. We know for sure what the nutritional value of wheatgrass is, and defense isn't contesting that the substance found inside baby Woya is something other than wheatgrass. We know not only through the state's nutritionist what wheatgrass is, we know through the defense nutritional expert what wheatgrass is and what the nutritional value is. We know that it contains micronutrients, which are great, vitamins, minerals, and iron. Baby Woya had plenty of iron, but it doesn't contain any macronutrients. Macronutrients are calories and fat and protein. And to keep the body is just a biomechanical machine made up of cells. And to keep the body running, you have to provide it with fuel. Vitamins aren't fuel. Minerals aren't fuel. You need fat, you need calories, you need protein to keep the body from breaking down. And that was what the wheatgrass was lacking. Great source of vitamins, but it doesn't provide nutrition.
But was there another formula, kind of concoction? Because there wasn't evidence that she had anything else in her system, at least at the time. So, but what the Andreessens and the defense are contending is that she provided a separate formula, some kind of concoction that she made up, a baby formula that she was also using to supplement the baby's diet.
Right. There was testimony that there was almond milk and coconut water, but we heard from the defense nutritional expert as to what the value nutritionally of those are as well. And even the defense expert had to concede that coconut water and almond milk are also low in calories, low in fat, low in protein. So it's the same situation whether you go with the almond milk, whether you go with the coconut water, or whether you go with the wheatgrass. And by the way, the only evidence in this case is that baby Woya was, in essence, I believe marinated was the word that Dr. Mote used. Baby Woya had wheatgrass stains on her fingers, on her mouth, in her GI tract. That means the tube that goes from the mouth all the way down through the stomach to the colon, coming out of the anus, in her diapers, soiled diapers, but not feces, but wheatgrass found in her diapers. So there's no question. The word red herring comes to mind when I hear a question like that as to whether or not that somehow impacts the state's ability to prosecute for aggravated manslaughter.
Sure. All right, well, it's fascinating to hear all of this. Getting the facts right here. All right, well, we heard the testimony from the Andreessens' own young children testifying against them, and the boys said a few things that could prove to be detrimental for the defense.
What person can devise the thought of bringing in a 9-year-old and a 7-year-old child that hasn't seen its parents in 28 months and get them to say, my parents killed my little baby sister, because that's what the state is going to brainwash them into saying.
Well, the defense says the children were brainwashed. And Herb, how much did you prep Joshua and Micaiah, and what made you decide to put them on the stand?
Kim, that's an excellent question. The fact of the matter is that because of the severe traumatization of these children, when I had the opportunity to meet with them 2 or 3 times prior to trial, in fact, all I could do when I met with them was to get to know them as people, really, to spend time around them so that they wouldn't be uncomfortable around me, so that they wouldn't be afraid when I brought them into court. We really couldn't talk in any great detail about what happened, because every time I brought up the issue, they would cry, and I didn't want to traumatize them
Meaning if their
anymore.
little baby sister dying,
yeah,
it's
the
very
issue,
traumatic,
sure. And, you know, they did mention that our baby sister died. You know, she died because of the vegetables. And then they would cry. So that led me to believe that I could do more harm to the children by forcing them to answer questions then and there. The question as to whether or why I actually decided to put them on the stand, that was decided for me by the United States Supreme Court. They've made a ruling in a case called Crawford versus Washington that if you want to use child hearsay in a case such as this, you have to give the defendant an opportunity to cross-examine the child hearsay declarant. In this case, without putting the children on the stand, all of the statements made to the University of Miami's child protection team could not be admitted because that would be violative of the Crawford case determined by the United States Supreme Court, so they had to get on the stand.
Yeah, and so if you didn't do that, then he'd complain and file an appeal, and you would, yeah, the case would get reversed. So you wouldn't be allowed to bring that in, but he was allowed to have the opportunity to cross-examine them.
Absolutely.
And have the benefit of that testimony. Well,
Absolutely.
it seems you had such a great rapport with the kids. You told me during one of the breaks, they would play and jump on you, and just really seemed to like, they called Mr. Herb and Mr. Walker their friend.
Yeah, it was interesting how quickly they seemed to grow attached to me, and unlike what was suggested, I think, by defense, it wasn't as a result of any chocolate. I just think that they tended to like me, and I liked them back.
Well, that's really nice. Yeah, no bribing the witnesses with chocolate. You can bribe me, though. Well, I have definitely gotten a chance to ask some questions to Prosecutor Herb Walker, so now it's your Well, there is still time to get your thoughts into both sides at CourtTV.com and answer our email question of the day. What is true justice in this case? Send us your answer, because it just might end up being our choice for email of the day. And in the courtroom now, a new witness has been called to the stand during the state's rebuttal case, and this is Dr. Renard Mota, right? Mota. Dr. Mota testified during the state's case in chief, and he is the medical examiner who performed the autopsy on the victim. Let's take a listen.
Dr. Binky testified to the jury prior to now that the term pro-patient ductus arteriosus is a type of heart defect. Was that accurate or not?
No, it's not accurate. It's a normal finding in a child of this age.
All right.
It's not a heart defect.
Additionally, there was a comment made about T cells coming from the bone marrow as opposed to coming from the thymus. Was that a correct statement?
No, that's incorrect. T cells are called T cells because they come from the thymus. Thymus begins with a T. B cells come from the bone marrow. That's why they're called B cells.
So it would not be correct to say that T cells can come from bone marrow?
That's false.
Now, with regards to the testimony of Dr. Maricini, did you have an opportunity to sit in and listen to the testimony of Dr. Maricini?
Yes, I did.
All right. And did you find that he misstated your testimony and the facts in the case in many instances?
Objection. Sustained.
Did you disagree with some of the statements that he made with regards to medical terms and medical conditions relating to baby Woya?
Yes, I disagreed.
All right. Specifically, with regards to air found in the stomach, what, if anything, can you tell the jury about the presence of air in baby Woya's stomach that differs from what Dr. Maricini told the jury?
Well, Woya, at autopsy, Woya had air not only in her stomach, but throughout her entire intestines, all the way down to her rectum. Now, we do autopsies on people, and fire rescue, you know, they pump air into the lungs, and sometimes air gets into the stomach, but it doesn't go beyond the stomach. At the end of the stomach, there's a tight muscle called a sphincter. So it's like having a rubber band around the end of the stomach. There's going to be air pumped in there from trying to, you know, get air into her lungs, but it's not going to go beyond that, and it's certainly not going to go through all of her intestines all the way down to her rectum. The reason her intestines were full of gas is because she was filled with grass, and she's not able to absorb grass very well. It's like when people eat a lot of salad, they get all gassy and bloated. That's what you had in Woya. It's not from CPR. There's no way you can do CPR and have air go all the way through the stomach, through whatever 20 feet of intestines, and come out of her rectum.
All right, now, Dr. Maricini made reference and drew a diagram that's on the board behind you, Defense Exhibit J. And on that drawing of baby Woya in her stomach, he wrote the word coercitor.
Right.
What is coercitor?
It's a protein calorie deficiency. It's a physical state due to not enough protein and not enough calories.
Did you ever suggest in your medical report or in your depositions or in any of your conversations with the state attorney's office, the jury, or the defense attorneys that baby Woya was suffering from coercitor?
Objection meeting. Overruled.
Did you?
No, I never used that term, ever.
Did you ever suggest that coercitor is what she was suffering from?
No, protein calorie deficiency.
All right. Now, with regards to gas in the belly, what, if anything, can you tell us about the gas being in the belly? Dr. Maricini made a point to point out to the jury about gas in the belly.
Well, there's some gas in the stomach, and some of that can be from CPR as they're trying to blow air into her lungs. But where we differ is that it continues through 20 feet or so of intestines and comes out of her anus. There's no way you can blow air into her lungs hard enough to have her fill up completely with air and come out the other end. That's nonsense.
Yeah, because she's a human being, not a balloon. All right, we're going to have more from the courtroom, and we'll get back to our panel of special guests. Before we get to that, we're going to check in with Amanda Grove in the CourtTV News Center for the rest of the day's legal news. Lamoya and Joseph Andreessen are in a court of law facing 50 years in prison for starving their youngest child to death. Now, since their arrest, the couple has been placed on house arrest, resulting in the birth of another child. Welcome back to Both Sides. I'm Kimberly Guilfoyle Newsome, and in the courtroom, Dr. Mote, the medical examiner who performed the autopsy on Woya Andreessen, is continuing with his testimony. Here he explains his conclusions to the jury.
Dr. Maricini made a suggestion that this case, or your findings, were suggestive of starvation. Did you ever suggest that baby Woya was starved?
Never. Never. Absolutely not. And I think I made that distinction clear. I distinguished starvation from malnutrition. If she were starved, then she would not have been fed anything. No food, no water, nothing. I've never used that term, and I've made that distinction clear.
Is that distinction between starvation and malnutrition an important distinction?
To me, it's very important, yeah.
When Dr. Maricini told the jury that there was no evidence of starvation, as Dr. Mote had suggested, and pointed out certain things that were not present, was that accurate, and with regard to what you placed in the medical examiner's report?
Objection, mischaracterization. Staying just to the form of the question, just rephrase it.
I didn't understand the question.
Yeah, I thought it was a little long, so rephrase it anyway. The doctor didn't understand.
Dr. Maricini stated on his direct examination that you found that the baby had starved to death. Did you find that one?
No.
All right. And then Dr. Maricini went on to tell the jury about several findings that weren't present, that should be present where there is starvation. What, if anything, can you tell us about the fact that there were high levels of iron stores in the body of baby Woya? Does that affect your determination of malnutrition?
It actually helps support it, because I know in wheatgrass there's a tremendous amount of iron. It's a good source of iron. And even Dr. Maricini said the iron stores were a little high. It may not have been a little high, I forgot what phrase he used, but they're higher. But she's getting iron through the wheatgrass, so all he's done is support my conclusions.
Should there be iron in high supply in a starvation case as opposed to malnutrition?
If starvation case, you don't have it coming in, your iron levels are going to go down.
All right. Now, what about B12?
B12, again, B12 deficiency, B12 only comes from animal products, not from plants, not from nuts. It only comes from animal products. If you have B12 deficiency, it takes 6 or 7 years for you to develop B12 deficiency, because we've all got enough B12 in our bodies to keep going for several years before we start running low. Well, Woya never even lived long enough to make it to 6 months, let alone 6 years. So her not having B12 deficiency because she didn't have megaloblastic anemia, which is something you see under the microscope in the bone marrow, that doesn't surprise me. That just supports the malnutrition.
So the fact...
All right, let's bring back in our other guest, Dean Rosado. It seems to me that this is such a tough case because you have the other surviving children. Yes, they've been separated from their parents, and now they're having a diet that they enjoy. They testified and talked about how much they love eating tacos and staying with their Aunt Mary, and that they love her so much. What kind of impact can that have, and do they factor these type of things in terms of what is in the well-being for the children?
Well, that's a very complicated question, but we start with let's say, if the parents go to jail for a short time or not at all, which is possible if there's an acquittal or a partial acquittal, then the question is, how do we have a reunification with the children and the parents? And we do favor the biological parents. We don't want to automatically send the children to auntie if the parents are capable. One of the things that happens in these cases is to find out if the parents are willing to agree to conditions, like they will maybe not feed them tacos, but will feed them an adequate diet. I think the other thing that's difficult here, and it does relate the criminal and the family court cases, is that what Herb said earlier is that there hasn't been visitation. And in fact, when you hear one of the child's testimony, they call Auntie Ma. And that doesn't sit very well with me, because it means that they're becoming attached to the aunt like a mother. It's going to make the transition difficult. But the court, I think, will try to see through that, favor the parents if there's a possibility that there can be a successful reunification.
But children at that young age, I mean, they're very resilient, but also, can you blame them for wanting to be attached, for, making friends with Mr. Walker, feeling comforted? It seems that there are children that were also starving for a little love and affection, not just food. And it's easy to make those attachments, I think, especially in the absence, of a parent.
That's generally so, and there's certainly, the more love and attention and affection that they get, that's very important. But I think that, as we found, when we have children in foster care 2, 4, 5 years, and we don't necessarily have them calling their foster parents their mother, and we do have to worry about, I think, that it causes another trauma of going from one to the other. And so I worry about that there's been something going on at that home in terms of what we call maybe alienating the parents, and that's something that the court's going to have to look into. Okay,
and that would be, of course, separate from the criminal court, and that's something that
afterwards,
Child and Family Service would have to come into. And Herb, I want to talk to you about that. You're a compassionate person. I've been getting to know you. I know you have the children's best interests at heart. And in the beginning of this case, didn't you try to do something to see if the family maybe could stay together and work out some kind of agreement in the case?
Well, there was discussions with prior defense attorneys as well as with the defendants regarding the possibility of them agreeing to abandon the imposition of a strict raw food diet upon the children, and they opted not to go with that. They indicated that, in essence, they wanted to go for it, and they had a right to go to trial, and that they didn't want to change their viewpoint on feeding children. They weren't asked to change their view on how they feed themselves, but in light of the danger that was apparent to the 4 children that survived, as well as the baby boy who did not survive, the parents did not indicate that they wanted to consider giving up that lifestyle for the children.
Right, so you said, hey, look, do what you want with yourself, eat all the wheatgrass and almond milk, whatever you want, follow your own lifestyle for the parents, but you said, we need to make a modification here with respect to the children, because they're clearly, none of them were getting the nutrients and the nourishment that they actually needed to thrive.
Right.
And they were not interested in doing that, and they said they wanted to go to trial, even though you were willing to offer them some kind of plea, disposition or...
Sure. The best interest of the children was certainly at heart when we considered the possibility of resolving the case without having to go through trial. But again, they had a right to determine that they didn't want to, and that's what they chose. That made clear to the state that they feel so strongly about this raw food diet for the children as well as for themselves, that they were going to impose that upon the children regardless of whether or not a trial would be held, or regardless of whether there was a penalty.
They break up their family. Yeah, and so you weren't sitting there at the outset saying, I want to give these people 50 years.
Oh, absolutely not.
That's just the highest level of the sentencing range of what's possible under the guidelines.
Absolutely not. In fact, at the Miami-Dade State Attorney's Office, a group of us, the most senior attorneys in the office, as well as members from the police, the medical examiner's office, Department of Children and Families, the University of of Miami, we all met together and we all discussed the possibility of working out some type of a plea that would entail some type of a probationary sentence with counseling and the like. And we agreed that that would be an appropriate thing to attempt to pursue with the defendants, but they were not interested in that
They
at all.
declined. See, I mean, this is where you get the truth when it comes out, because comments have been made that, you know, prosecution's the bad guys. No, they're not. When we come back, our panel weighs in on the ultimate question in this case. Are the Andreessens guilty of the top charge of manslaughter? It's sure to be a heated debate. Stay with us. Are Joseph and Lamoya Andreessen guilty of manslaughter? Log on to CourtTV.com and vote on today's 13th juror question. So far, 81% of you say yes, while 19% of you are voting no. So please log on and vote. Keep sending the emails as well. We're reading through all of them, and they are fantastic. We're going to be updating the results throughout the day. So right now, as we stand, 81% to 19%. Dean Rosado, I'm going to put you on the hot seat here. What do you think about 13th juror question? How would you vote?
I'm actually surprised at how it's skewed. I don't know if the viewers have seen all of the testimony. I've seen bits and pieces of it. I think there is a really close question on causation here, and I think that's something that the jurors are going to have to wrestle with. That is, what really caused the baby's death? Is it the malnutrition, or was it this DeGeorge syndrome that I think that the defense has done a decent job of putting that on, and just saying, well, if it could be either one, it's not proof beyond a reasonable doubt.
Well, that's interesting. Herb, you want to respond to that?
Yeah, in response, if there are T cells, there can't be DeGeorge syndrome, period. And there's no question.
It's impossible.
Game over. There cannot be. Partial DeGeorge would be the next fallback. You could have T cells and have partial DeGeorge, but partial DeGeorge does not kill. Partial DeGeorge has signs such as macular dysmorphia, funny face, the heart arch should be deformed. There should be internal organ evidence.
And I saw the photos. You brought them. We can't show them on the air, but I saw you showed me the autopsy photos. That was a beautiful baby girl.
Absolutely, except for the fact that the baby
Except for
had...
the body was literally skin and bones.
And Dr. Mote pointed out, as well as Dr. Haima, and I believe even the defense expert geneticist indicated that the having a DeGeorge syndrome alone cannot cause fat to disappear like magic. And you saw the photographs, Kim,
yes.
And you saw that where there should be an inch thick of yellow subcutaneous fat, there's nothing.
There was nothing. Yeah.
So DeGeorge syndrome and partial DeGeorge syndrome are exclusively and absolutely ruled out, just as the medical examiner told us during his testimony in the direct case and in the rebuttal case, and Dr. Haima agreed with him, and that concludes the issue of DeGeorge.
Well, it's interesting because when you look at those photos, it's so compelling, and you see the little baby, and having prosecuted many of these cases and dealing with child abuse, etc. You look at her body and you see the skin. It's pulled so tight across the chest, and you can see all of her bones coming through the skin, and the arms, the skin is shriveled like an old woman.
Right. I believe a couple of the witnesses, particularly Cassandra Butler, who was a registered nurse and a friend of Lamoya and Joseph, she indicated that the child looked so disturbing that it looked like a poster child for a third world refugee country.
As bad or worse as I've seen, honestly, with the UNICEF campaigns. That's how this little baby girl, I mean, if somebody saw her naked and like that, they would, I mean, it's horrifying.
One of your viewers yesterday, I believe it was, said that, look, if you were driving down the street and you saw a bunch of dogs in someone's backyard chained to inside of a fence and their ribs were sticking through their skin, someone would call the animal abuse hotline and they would come and remove those dogs.
By the way, I've done that. I've made those calls. When you see a starving animal with the bones sticking out, you call.
And the owners will be prosecuted for abusing an animal.
Absolutely.
So in the case of a child, how much higher is our obligation? How much higher is our duty to protect children who can't talk, just like animals can't talk, Babies that are 6 months old can't say, I'm hungry, feed me, my ribs are sticking out.
That
from my
was our
skin.
winner yesterday for email of the day, saying we have to protect those that have no voice, like little baby Boya. All right, when we come back, more from the courtroom, but first, while we're in this commercial break, please take a moment to head over to your computer and send us an email to bothsides@CourtTV.com and answer our email question of the day. And don't forget to send us questions for Prosecutor Herb Walker. We'll be right back.
Did you notice any weight gain during the first week?
Yes,
How much would you say the children gained in the first week that they stayed with you?
roughly between 3 to 7 pounds per child.
Now those children, now that they've gained weight, are they fat and obese and out of shape?
No, they're not.
Well, Aunt Mary wasn't popular with her nephews because she spoiled them with treats. She became a favorite aunt because she gave the children one of life's necessities, food. Welcome back to Both Sides. I'm Kimberly Guilfoyle Newsome. Vinnie Politan is off today. Since Mary Andreessen took the children into her home, they gained 20 pounds and grew more than a foot. But were they healthy before they moved into their aunt's home? That is a question for the jury. And in the courtroom now, Dr. Mote is wrapping up his direct examination and is about to face cross by defense attorney Ellis Rubin.
Could have T cells and not have a thymus. Was that correct when he told the jury that?
No, T cells originate from the thymus. That's why they're nicknamed or called T cells. T is from thymus. Without a thymus, you don't have T cells.
Dr. Maricini suggested that the CD3 test that you ordered to be done in this case does not conclusively